Hi everyone, this is the final video. It will represent our final lecture. It is the lecture that was to take place on March 31st. For this lecture, we are going to deal with catastrophic impairment, as well as the interplay between tort and SABS claim. So for the purposes of catastrophic impairment, we are dealing with the statutory accident benefit schedule, and then we will conclude the lecture by looking at how both tort claims and SABS claims are intertwined, because as you should know by now, they are very much interrelated, and what happens on one could very much impact what happens on the other. So when we think of catastrophic, we think of the worst possible situation you can imagine. And hopefully everything that's happening right now with this pandemic does not get much worse, because you may be able to equate that to the term catastrophic given all of the fatalities. But with catastrophic in the statutory accident benefit schedule, what we are dealing with are what were meant to be the worst types of injuries, the ones that require the highest level of care on a medical, rehabilitation, and attendant care front. And so what I want to look at as part of this lecture is the test that existed for catastrophic impairment prior to June 1, 2016 and post June 1, 2016. It's important to note that this test very much changed. So not only did the monetary amounts that are available change, so too did the test to determine whether or not someone has suffered a catastrophic impairment. So prior to June 1, 2016, the individual would have had $1 million in medical and rehabilitation coverage and an additional $1 million in attendant care coverage. Since June 1, 2016, those benefits have all been combined such that the individual only has $1 million in medical, rehabilitation, and attendant care coverage. The definition prior to 2016 was somewhat complicated, but it listed a number of avenues by which someone could be deemed catastrophic. With the changes that came into play post June 1, 2016, the Ontario government made it much more difficult to meet that definition. So we're going to look at both the pre-June 1 and the post-June 1 definition, as well as any other issues surrounding catastrophic determination. So why is catastrophic impairment important? And it's important for a whole host of reasons, because here we're looking at which category of medical rehab and attendant care benefits the individual will be placed in. And there's a lot of money at stake. So let's look at the various reasons as to why it is important. First and foremost, the increased limits of attendant care and med rehab will be available to the individual if he or she is deemed catastrophic. So remember, under the current legislation, there's $65,000 in medical, rehab, and attendant care benefits available if the individual is non-catastrophic versus $1 million that is available if they are catastrophic. Prior to June 1, 2016, it was the difference between $2 million in catastrophic benefits and $50,000 in med rehab and $36,000 in attendant care for non-catastrophic claimants. So there is a very significant monetary difference here. The other reason that it's important is the catastrophic benefits can really provide a lot of money in cases where there is no liability and therefore no tort claim. So if the individual does not have a tort claim to fall back on, they need to ensure that they are accessing all of the medical, rehabilitative, and attendant care benefits that could possibly be available to them. That may be their only chance of accessing key treatment needs. The third reason is that the catastrophic benefits will also provide significant money where there is no insurance. So think of the case where there is a severe injury requiring millions of dollars in care, but the third party only has $1 million in insurance limits. The SABs will enable that individual to get the treatment that they need. And if that person is not deemed catastrophic, they're restricted to that $65,000 and whatever the tort limits are. So the SABs do provide a significant amount of money for catastrophic impairments over and above the tort limits that are available. Now, the catastrophic definition has been part of the statutory accident benefits schedule since as early as 1996. The purpose of the definition was to foster fairness for victims of automobile collisions by ensuring that those with the most needs or the most significant needs have access to expanded medical and rehabilitative and attendant care benefits. It was originally thought, though, that impairments, other than blindness, amputation, paralysis, or severe brain injury, but it was thought that the impairments that would meet the definition of catastrophic would be few and far between. Now, thankfully, the courts and the arbitrators who have heard disputes stemming from catastrophic determinations have adopted a much more liberal and humane approach, leaning more towards inclusion in the definition rather than exclusion. Even chronic pain cases have reached the level of catastrophic, thereby allowing people to access the resources needed to minimize pain and impairment. So this really has been an interesting development of the law in this particular area to see the types of cases that will fall within that category. They are not always the most horrific cases that you can imagine, but they are typically very serious cases where the individual has high level needs. So how do we know if a claimant is catastrophic or CAT, as most of us will say? Now, the statutory accident benefit schedule sets out a detailed definition of catastrophic impairment at section 3, subsection 1 of the SABs. These definitions are very complex and even more complex with the changes that came into effect on June 1, 2016. It is not always clear if someone will or will not meet the test. As an assessment or a number of assessments by a number of medical specialists are often required and can be quite extremely costly. There is case law emanating from the License Appeal Tribunal, however, that indicates that the insurance company is required to pay the cost of the insurer-selected CAT assessments, and that also includes paying the cost of the assessments that the insured person arranges as well. So if the insured person wants to see if they could potentially be catastrophic, an OCF 18 treatment and assessment plan can be submitted by a assessment company, indicating that the assessment company will do a number of assessments to see if the individual is catastrophic. I do those quite frequently. Often they range anywhere from as low as $16,000 to as high as over $20,000. The insurance company is required to pay for those assessments, and if the assessments come back that the individual is catastrophic, an OCF 19 application for catastrophic determination would then be submitted by the assessment company. Now, when the insurance company pays for those assessments, which are arranged by the insured person, the insurance company is obligated to pay them outside the medical and rehab limits. So remember, when the individual is non-catastrophic, he or she only has $65,000 in benefits available. The cost of the catastrophic assessments do not decrease those limits. So they would be paid over and above the $65,000 that is available to the individual. So let's start by looking at the catastrophic definition as it was prior to June 1, 2016. And so the SAB set out all of the criteria by which someone could be deemed catastrophic. The first was paraplegia, which would be paralysis of the legs and the lower body. The second included with that was quadriplegia, which is paralysis of all four limbs. So obviously, if those were injuries that someone sustained in a collision, they are certainly very severe, lifelong injuries that will require substantial rehabilitation. The second was amputation of an arm or a leg or another impairment causing the total and permanent loss of use of an arm or a leg. So only amputation of one limb was required. The third was the total loss of vision in both eyes. And the fact that both eyes were required to be impaired was important here because often you would see situations where someone had an impairment in one eye but not both. But in order to classify as catastrophic, there needed to be a total loss of vision in both eyes. Now, before I continue on with the other criteria by which to be deemed CAT, it's important to know that the individual need only meet one of these criteria. They don't require all of them. So if someone was a paraplegic, they would automatically meet the catastrophic definition. If someone had an amputation of their leg, they would automatically meet the definition. Or if they had a total loss of vision in both eyes, they would automatically meet the definition. In addition, there is also brain impairment. And so if someone had a brain injury, they could also classify as meeting the definition. For brain impairments, there needed to be a score of 9 or less on the Glasgow Coma Scale. Now, this was a test and still is a test that is typically administered by emergency personnel. So the ambulance attendant, for example, would do a Glasgow Coma Scale reading at the time of the accident when they arrive to assist. And typically the ambulance attendant would do this assessment multiple times throughout their assessment of the individual. The ER nurses and physicians would also similarly do this test. And the purpose of the test is to determine the individual's level of consciousness. And it's rated on a scale from, as low as 0 all the way up to 15, with the lower the score, meaning the more unconscious the individual is. And so what the SABs required was a reading of 9 or less to meet the catastrophic impairment. And that reading could be on the ambulance call report or could be in the emergency room as well. With respect to brain impairment, a score of 2 vegetative or 3 severe disability on the Glasgow Outcome Scale, which is a different scale that looks at the individual's level of functioning, could also classify the individual for catastrophic impairment if that test, if those test results were administered more than 6 months after the accident. So the next way in which someone could be deemed catastrophically impaired is through the 55% whole person test. And in essence, what happens here is a number of medical professionals would assess the individual and would identify the impairments the individual suffers. So they could include an impairment of the individual's range of motion in their shoulder, an impairment with respect to their knee, mental or behavioral impairments, so on and so forth. So they come up with a list of all of the individual's impairments, and then they rate each of those impairments with the ratings attributed to them by the American Medical Association's guides to the evaluation of permanent impairment. If the totality of those ratings equal 55% or more, the individual would then be deemed to have sustained a catastrophic impairment. An additional way in which someone could be deemed catastrophic is through a marked impairment. And this is really focused on psychological impairments. And with respect to psychological impairments, they are rated on a different scale via the guides, the American Medical Association's guides. And if there was a marked impairment, so a class 4 impairment, the individual would then be deemed to have sustained a catastrophic impairment. So those are the list of all the various types of impairments that could classify as catastrophic. There are three that we typically deal with on a regular basis, and the big three are these. The GCS, and again, we're talking pre-June 1, 2016. So remember, the GCS of equal to or less than 9 relates to brain impairments. The second is the 55% whole person test, where you add up all of the impairments, and if they equal to or are greater than 55%, the person is catastrophic. The third relates to there being a single marked impairment. That again is attributable to psychological impairments. These are the three elements or the three criteria that typically involve the most dispute. There is no dispute surrounding whether or not someone has an amputation for the most part or paralysis. But it is these three criteria that the bulk of the case law deals with. So what I want to do now is look at some of the pre-June 2016 case law, because there really isn't much in the way of case law dealing with the post-June 2016 test. And so I want to look at how the courts and adjudicators dealt with the issue of catastrophic determination under the prior test. The Liu decision is one of the first or one of the key decisions that deal with that test. And Liu is a case that relates specifically to the issue of GCS. And so remember the criteria being a score of 9 or less on the Glasgow Coma Scale. And what the court in Liu looked at is whether or not an individual requires more than one rating of 9 or less, and what happens in the situation where there's, for example, a rating of, say, 6, and then the individual quickly bumps up above 9 and has no ongoing functional issue. Would that individual still qualify for catastrophic determination? So remember, the Glasgow Coma Scale is that scale that's used by emergency responders and typically the ER staff in the hospital to determine an individual's level of consciousness. It is a neurological scale which really aims to give a reliable and objective way of recording the conscious state of the individual. the person is assessed against the criteria of the scale, and then the resulting points the person is given determines their level of consciousness, which can range between 3, indicating a deep level of unconsciousness, and either 14 or 15, which in essence indicates a fully conscious state. Now, with the Glasgow Coma Scale, there are 3 ratings that are made. The first relates to eye movement. So does the person, for example, open their eyes, not open their eyes spontaneously, open their eyes in response to pain? And there's a corresponding number associated with each one. So the individual would be rated from a rating of 1 for does not open eyes, all the way up to a rating of 4 for opens eyes spontaneously. The second criteria that's rated is the individual's verbal ability. So whether or not the individual makes sounds and if those sounds make sense. And on this rating, the individual will be rated from 1, meaning makes no sounds, to 2, makes some sounds, to 3, is able to form words, to 4, is confused and disoriented, all the way up to 5, which indicates the person is oriented and converses normally. The third element that is rated is the individual's motor movements. And those ratings also stem from 1 to 5, with 1 being makes no movement, 2 being extends to painful stimuli, 3 is an abnormal flexion to painful stimuli, 4 is a flexion or withdrawal to painful stimuli, to 5, which is localizes to painful stimuli, and all the way up, there's actually a 6 here, to obeys commands. And based on the ratings the individual is given for all 3 of those, they will end up with a score between 3 and 15. Now, what the case law was looking at is what does a score mean? Because if you look at next to Roman numeral I, it indicates a score of 9 or less. So does A mean only 1 score of 9 or less? And again, what if that score occurs after the individual is medically sedated? Does that score count? And then if you continue on after Roman numeral I, it indicates according to a test administered within a reasonable period of time after the accident. What does reasonable period of time mean? Does it have to be within 24 hours of the accident or less? Or is more okay? And there were a lot of sort of unknowns with this as to what would particularly apply here. This is highlighted in yellow, the GCS ratings in the Liu case. And Liu was a case where the insured person was struck by another vehicle, actually hit the third party's windshield and was thrown over the top of the vehicle and landed on the roadway. And like I said, these are the GCS scores highlighted in yellow. So you can see the first score, there was 1 assigned for eye movements, 1 assigned for verbal, and 1 assigned for motor, for a total of 3 for the GCS rating, and that's at the top of the screen. And if you go down further, the next score was 4, 3, and 5 for a total of 12. And then the next 3 scores all totaled 14. So there was, in fact, 1 score that did not exceed 9, but all of the others did, and the individual quickly improved in their level of consciousness. And what the evidence was is that the GCS score was almost back to normal within 45 minutes of the collision. And so in that situation, would this particular individual still qualify for catastrophic determination? and this case went all the way to the Court of Appeal. The insurance company argued that so long as it established that the accident caused, the insured person established that so long as Lou was able to establish that the accident caused at least one GCS score of 9 or less, Lou would qualify for catastrophic determination. It did not matter that the GCS quickly increased. The fact that all subsequent scores are 10 or greater should be irrelevant to the statutory analysis. The insurance company, however, argued that the insured should not be deemed catastrophic because his GCS scores rose to 12 out of 15 within 33 minutes of the collision, and because those scores continued to rise thereafter. The insurance company felt that this period of time is well within what would be considered reasonable in all of the circumstances of the case. Now, at the Court of Appeal, the court held that you only require one score of 9 or less to qualify for catastrophic impairment, so long as that test was administered in a reasonable period of time after the accident. So in the Lou case, the GCS measurements were done by the paramedics when they arrived at the scene. This was most certainly within a reasonable amount of time. The other thing that the court said is the definition of catastrophic is a legal test. It is not a medical one. And from a legal perspective, there is one score here of less than 9. So it does not matter in terms of this legal test whether the insured person makes a good or a bad recovery after that initial score. What really matters is that there is a single score of 9 or less, and the legislation really creates a bright line rule. Now, there are other cases that have looked at the GCS issue. For example, one would be the initials MM and Guarantee Company of North America. And in that case, they looked at the situation where the individual was medically sedated. And the test or the question asked was whether the GCS score would have happened but for the brain impairment, or whether the brain impairment materially contributed to the impaired level of consciousness. And so in essence, what they're looking at is if the individual was medically sedated because of a brain impairment, was it the brain impairment that caused the low GCS score, or was it the medication that was given to sedate the individual? And what the arbitrator determined is that the test is really a material contribution test, and that this test is less strict than the but-for test. There is no need to show that the GCS would have fallen to 9 or less without medical intervention. So long as the insured person shows that there is an injury that materially contributed to the brain impairment and that the GCS score fell below 9 or less is sufficient. So as an example, if someone has a heart attack with no head injury and is intubated for surgery, the GCS is caused solely by that intubation, and it has nothing to do with any brain impairment. But where there is a brain impairment and other factors may or may not have contributed to the GCS, we don't need to prove that the GCS would have fallen to 9 or below if the other factors, such as intubation, didn't exist. So long as the brain impairment is there and the individual falls below the threshold, the individual will be deemed catastrophic. So the bottom line emanating from the Lou decision and others is that all that is required here is a single score of 9 or less, and the level of recovery the individual makes following that score is irrelevant. Now, as you know, and I've mentioned, the GCS test is no longer used. It's really unfortunate because the GCS scores were a widely used scoring system that was used by emergency responders. So it was very easy to determine what the score was and therefore make the catastrophic determination. The big criticism, though, of this test by the insurance industry was that there were a lot of individuals that would have this low score, similar to what you see in the Lou case, and then would quickly improve and would have no functional difficulties. And so what was happening is that people were being deemed catastrophic who really didn't have a severe injury or didn't have the need for rehab. And so insurance companies were forced to keep these files open with the potential exposure hanging over their head when people didn't really need the catastrophic benefits. And so they were very much pushing for a system that would be more based on the individual's recovery and functional impairments rather than whether or not there was, in fact, a brain impairment. And then that prior slide really just summed up what I've already said to you. So let's move on to the second decision that I wanted to talk about. This is the Kuznets decision. And this is an important case. It's really dealing with this definition. So the 55% whole person test. And the issue in Kuznets was whether or not the individual's impairments on a physical and a psychological front could be combined to determine if the individual meets the test. Because as you will recall, another element of the catastrophic test is the marked impairment, which deals with psychological injuries. And so what the insurance industry was arguing was that this 55% test should relate strictly to physical impairments. There should be no combination of the two, being physical and psychological impairments. Now, the American Medical Association's guides really set out, every potential impairment that an individual could have and requires ratings with respect to each system. So it talks about 10 bodily systems, skin, as well as mental and behavioral disorders, and it requires an impairment rating for each. So the assessor is directed to evaluate each organ system impairment as a percentage of the individual's whole person impairment. And then there is a combined value chart towards the end of the book, which requires all of the impairments to be added up together. And what this chapter purports to do is to estimate the impairment of the individual's whole person. And the assessors will use the guide to, in addition to rating the physical impairments, to also attach a percentage to the individual's mental and behavioral disorders, which really does go to their psychological impairments as well. So this is what the guides look like, and this is the 4th edition that was previously used under the new legislation. I believe they moved up to either the 5th or the 6th, but the 4th edition was used prior to June 1 of 2016. And this here would be the combined values chart. So this is the chart that assists you in adding the numbers together. And so what happens is you pick a number on the left-hand side, and you can see highlighted in yellow is the number 30. And then you pick the appropriate number on the bottom of the chart. I also have 30 highlighted. And then you scroll up and across until those two rows and columns meet. And you can see highlighted where they meet is 51. So a rating of 30 plus a rating of 30 would equal 51. It is not straight math. Each impairment has to be added per this combined values chart to get to the ultimate number. Now, when you rate these impairments, it is, very easy in some cases for an individual to meet the definition. So someone who has very severe impairments. Think of someone with numerous orthopedic injuries, long-term restrictions on the individual's mobility, and some psychological impairments as well. That individual will likely easily meet the definition. However, there was a significant gap in the legislation for individuals who sustained moderate physical impairments and moderate psychological impairments, because neither of these types of impairments on their own would qualify for catastrophic determination. But these individuals were often severely disabled because of the combination of their impairments. And it's been argued, as I said, by the insurance industry that because these are two separate categories of impairments, one for 55% and one for marked, the combination of the impairments should not be considered under the 55% category. Now, victims' rights advocates have argued that this would be incredibly unfair because these individuals are clearly severely impaired and certainly do need access to the higher level of benefits. And there can be no question that the combination of the individual's physical and psych impairments result in substantial disability and healthcare needs. So the unfairness of these types of cases was really dealt with in the Kusnerets decision, which is the seminal case emanating out of the Court of Appeal that dealt with this particular issue. Can you combine physical and psychological impairments for the purpose of the 55% test? Now, before I get into the facts of Kusnerets, let me show you this as well. This is from the AMA guides, and this is the mental or behavioral ratings that exists in Table 2 and Table 3. And so the assessor is directed to make a mental status impairment, and there's various percentages that would be assigned to each impairment, similar to the impairments that would be assigned to the emotional impairments. These would be the ratings, provided you combine the ratings, that would be used for the purpose of the 55% test. And so in Kusnerets, the court was asked, is it permissible to assign percentage ratings in respect of the insured's psychological impairments and combine them with the percentage ratings in respect of the insured's physical impairments to determine catastrophic determination? Now, Kusnerets was a December 2001 collision. The insured was badly injured and required an amputation below his knee. The difficulty was, at the time of his collision, in order to be deemed catastrophic, he had to have a double amputation. And so because he only had a single amputation of his limb, he did not qualify for catastrophic on the amputation alone. In addition to the amputation that he suffered, he also had ongoing deterioration with respect to his stump. He had difficulties using his prosthesis. He suffered sore shoulders, pain in his neck and lower back, headaches, visual disturbances. He had numb fingers, sore hips, knees, and a right ankle injury. He also suffered from both emotional and social withdrawal. He was diagnosed with chronic major depressive disorder and post-traumatic stress disorder. Now, Mr. Kusnerets sought a catastrophic designation in order to access that higher level of benefits, and he sought that designation on the basis that he suffered a greater than 55% whole person impairment. The insurance company held that he did not sustain a catastrophic impairment because, in their view, it was not proper to combine his psychological and physical impairment ratings. Now, he didn't meet the definition based on one or the other. So in order to hit the 55%, he needed to combine the ratings for his physical and his psychological impairment. At the trial level, the judge found that it was not permissible to combine the ratings, and without the combination of those ratings, he did not meet the definition and lost his case. The insured person then appealed to the Court of Appeal. And at the Court of Appeal, the court disagreed with the trial judge and determined that it is, in fact, appropriate to combine the physical and the psychological impairments. And there's 6 points that are important that emanated from the case. The first is that the definition of catastrophic impairment is to be inclusive rather than restrictive. And, this was an important pronunciation by the court, that there should be a combination because this is an inclusive definition. It is not to be restrictive. The second point that the court made is it is difficult to conceive of a broader definition of impairment. Catastrophic is meant to be a very broad definition, and it would be much too restrictive, the court found, to prevent an individual's combination of impairments from being rated for the purpose of the 55% test. The third point the court made is that the 55% test is really a catch-all provision for the benefit of those in the greatest need of care. And so really those that fall under the 55% are those who can't meet the catastrophic definition based on any of the other criteria. So they don't have the brain impairment that meted the GCS, and they don't have a psychological injury that meets the marked impairment, and so on and so forth. So the 55% test gives them a catch-all. And so because of that, it must be meant to have considered all of the individual's impairments to ensure that those who need the care the most are given access to it. Number 4, the guides are intended, these are the AMA guides, are intended to assess the total effect of a person's impairments on his or her everyday activities. So it would be contrary to those guides to only assess one aspect, such as the physical impairments an individual suffers. And then number 5, it is no excuse to ignore mental and behavioral impairments only because they are hard to measure. And one of the difficulties the insurance company raised is it's hard for doctors to rate the mental and behavioral impairments. They can sometimes change on a day-to-day basis, and it's difficult in an assessment setting to assign a rating to them. And the court basically said, that's no excuse. You still have to consider those impairments. Lastly, the court indicated that it would be unfair to deny an insured person access to enhanced benefits who meets the criteria just because of the combining of them. The combining is important because it will promote access to the highest level of benefits for those who need it. Now, the combination of the impairments really does produce the most consistent results with the SABs. And remember, the SABs are meant to be, as I mentioned, consumer protection legislation. The purpose of them is to ensure that the consumer or the individual insured is protected. And by combining those impairments and giving them access to the catastrophic benefits, that is the best way to ensure they are protected. The important thing to remember here too is deeming someone catastrophic does not mean they're going to receive $1 million or back before 2016, $2 million in benefits. The individual, all it really does is open the door for the individual. The individual still needs to prove entitlement to any of the medical, rehabilitative, or attendant care benefits that they are seeking. So, the bottom line from Kutzner's, what we know is that you can combine both physical and psychological impairments for the purpose of a catastrophic designation. And, this becomes incredibly important. There are a lot of cases that, you might think they would be catastrophic on the physical alone, but once the addition is done through the AMA guides, they don't make it. I had a gentleman in his 50s who was injured in a very severe head-on collision. He required 3 surgeries as a result of that collision, including a hip replacement. He ended up fracturing basically most of the bones on the left side of his body. He, at 4 or 5 years post-collision, was still attending for injections 1 to 2 times per week into his spine to help with the pain. He still required medications. He still participated in treatment. He walked with a pronounced limp, and he required a cane if he was to ambulate on any uneven surfaces. So the insurance company sent him for CAT assessments, and they did their own assessments, and I'll show you the results of those in a second. And what's important to know about these assessments is it's a 55% threshold, but the case law has determined that if someone hits 53, they will be rounded up above 55. So it in essence becomes a 53 and over threshold. So this is the results of the insurance company's assessments. And you can see at the top of the screen that they did an orthopedic assessment, a neurology assessment, a psychiatry assessment, and an occupational therapy assessment. And that based on all of those assessments, the combined impairment rating was 46% whole person. This emanated from a left hip impairment rating of 20%, a left shoulder rating of 2%, a left knee impairment of 1%, and then mental and behavioral impairments that they put at 20 to 26%. The assessors also looked at the marked impairment criteria to be deemed catastrophically impaired. And you can see their ratings there at the bottom of the screen. And they basically rated each of the 4 categories, which we will talk about more fully in a minute, as either mild or mild to moderate. And as a result, there was no marked impairment. So based on the insurance assessor's evaluation, my client did not meet the 53 or 55% whole person impairment, and he did not meet the marked impairment. Now, I took the insurance company's assessments and I had them sent to my own assessors. And I had, an orthopedic surgeon do an assessment. I had an internal medicine expert do an assessment, and I had a psychologist do an assessment. And you can see the ratings at the top of the screen that my orthopedic surgeon gave. It was 3% for medication use. My client was required, as I mentioned, to attend those regular injections. He also had to take regular medication, and there were side effects associated with those medications, such that he was entitled to a medication rating. They also rated him as 5% for his thoracolumbar spine and 5% for his lumbosacral spine. He received 5% for his shoulder impairment, 30% for his left hip impairment, 2% for his left knee impairment, and he had scarring of 5%. The internal medicine specialist and endocrinologist also gave my client ratings for his type 2 diabetes, which was aggravated by the collision and the weight gain that he had as a result, and the cardiovascular disease that he suffered. And so they put his physical ratings right on the nose at 53%. which didn't give us a lot of room if any of my expert ratings were deemed inappropriate. They also rated my client's mental and behavioral impairments and put him at the higher end of the insurance company's ratings, being 26%. So in the chart on the screen, you can see the difference between the focus assessments that were done by the insurance company and the Omega medical assessments that were done on behalf of my client. And I used this chart as we were preparing for the arbitration hearing to show really where my issues in dispute were. So as an example, we certainly had an issue with respect to the cervical spine where the insurance company put my client at 0%. There was no issue with respect to the lumbar spine. All of the experts agreed on that. Going further down, scarring and medication were certainly big issues. The insurance company did not rate them at all. Subsequent to my assessments, the insurance company had an internal medicine specialist also assess my client and realized that they hadn't given him ratings for his diabetes and his hypertension and added those ratings in. So they then gave them 5% for both of those categories. When all of that was said and done, it raised the insurance company's numbers up to 53%. My assessor's combined numbers were 65%. And so the dispute was, should my client be deemed catastrophic? And we got very close to the arbitration, but we were ultimately able to resolve the dispute. And my strongest argument was all I needed was 2 additional points to bring my client up to 53% and therefore have him deemed catastrophic. So there wasn't much further room, but these numbers become very, very important, and the ratings and keeping track of them and comparing them between the two assessors are incredibly important. Now, assigning ratings for the purpose of whole person impairment is still fraught with difficulties. It is far from perfect. The people who conduct these assessments require specialized training in the use and applicability of the guides. And that becomes a very good way to attack the validity of one of the side's assessments if the individual conducting the assessment is not certified to do so. It's also important to note that the AMA guides were never intended to be used for this purpose. They weren't intended to be interpreted like a piece of legislation. And despite the fact that the Ontario government has chosen to use them, the guides specifically caution against this. In the guides, it indicates it must be emphasized, and this is directly from the guides, it must be emphasized and clearly understood that impairment percentages derived according to the guide's criteria should not be used to make direct financial awards or direct estimates of disabilities. And that's precisely what we're using them for here. So certainly these guides are not meant for this purpose, and because of that, these ratings are not foolproof. The guides also state that the rating of impairments is not exact. It is instead based on estimates. And because of this, you often see the courts and the adjudicators interpreting the guides in a very liberal manner in favor of the insured person. The case law also indicates in favor that you err on the side of the insured person, such that if there is a range given, the insured person gets credit for the upper limit of that range. And that's why my assessors, when they looked at the psychological impairments and agreed with the insurance company's estimates, they went with the higher end of that range when combining the psychological and the physical impairments. This is in essence the conclusion of my case with my assessors is they took the 53% physical impairment plus the 26% psychological impairment and arrived at a combined impairment rating of 65%. Now remember that combination is done per that combined table. It is not straight math, and you can see 53 plus 26 does not typically equal 65. And so when doing the math with catastrophic impairments, that combined table must be used. Let's move on to the third case that I want to talk about. This is the Pastore and Aviva case. And this case relates to the criteria to be deemed catastrophic with respect to psychological injuries. So whether or not there is a marked impairment. Now, Chapter 14 of the AMA Guides provides the methodology to assess mental and behavioral disorders. So again, those are psychological impairments, and the impact of those psychological impairments on an individual's ability to function. Now, as we learned through the Kusnertz decision, is that psychological injuries certainly overlap with the 55% test. So they are determined for the purposes of the 55% as a percentage rating. But they are also determined on a scale from from no impairment all the way up to extreme impairment. And so similar to what we dealt with respect to the 55% impairment, an assessment would take place by a psychologist or a psychiatrist, and that assessor would be asked to assess the 4 areas of functioning as they relate to psychological impairment, and I'll go through those in a minute, and determine the level of impairment the individual suffers within each of those categories. So, this is the section of the SABS that we're dealing with. And again, in order to be deemed catastrophic, there needs to be a class 4 or class 5 impairment. Now, this is the table from the AMA guides that the assessor uses to assess the level of mental and behavioral impairments for the purposes of this category. And the question in Pastore was, when you look at the section of the statute, the legislation requires a marked or greater impairment, and the case law looks at what does A mean? Does there need to be one marked impairment, or does there need to be more than one marked impairment in order for the individual to be deemed catastrophic? So looking at this chart, you can see on the far left side that there are 4 categories that the assessor looks at. The first is activities of daily living. And these include the individual's self-care, personal hygiene, ability to communicate, ability to ambulate, ability to travel, sexual functioning, sleep, and social and recreational activities. So in essence, to what degree is the individual able to continue with his or her daily activities? Now, the test is qualitative rather than quantitative. So the assessor is not required to add up the number of activities the person can do versus those that they can't. But the assessor is to look at the overall degree of restriction or combination of restrictions from a qualitative perspective. So those activities that are most important to the individual would certainly, be more important in this analysis. The second area or aspect of functioning examined is social functioning. And for this, the assessor is looking at the individual's capacity to interact appropriately and to communicate effectively with others. Again, it is also a qualitative and not a quantitative analysis. And so when you think of social functioning, think of the individual who blows up for no reason and starts lashing out at others, or who, says things inappropriately, or who's socially withdrawn and doesn't go out. Those are all things that the assessor would look at. The third category is entitled Concentration, Persistence, and Pace. It's short form to concentration in the chart. And what the assessor looks at here is the ability of the individual to sustain focused attention long enough to complete everyday household tasks and to permit the timely completion of tasks at work. So, are they able to focus their attention and persist through a task at a reasonable rate? The fourth category that the assessors examine is the ability of the individual to adapt to stressful situations, and that's the adaptation category. So they look at the person's stress tolerance, what can he or she handle, and is stress and the inability to handle stress impacting on the individual's everyday life. Now, there are a number of ratings, and you can see they start with a class 1 rating and go all the way up to a class 5 rating. And the assessor will assign a rating for each of these 4 areas. So a class 1 would be a rating where there is no impairment at all. A class 2 would be impairment levels that are compatible with most useful functioning, and that would be a mild impairment. Class 3 would be a moderate impairment where their impairment levels are compatible with some but not all useful functioning. Class 4 is a marked impairment, and that's where they would be entitled to a catastrophic designation, and the impairment level in this case would significantly impede useful functioning, meaning that they're not able to perform the activities of those 4 areas in a useful manner. Class 5 is an extreme impairment, and in that case, their impairment levels would preclude useful functioning, meaning that they can't do it at all. So for a marked impairment, it doesn't mean they can't do the task, it means the task is impeded by their disability. So it is difficult for them to do it. It's not able to be done fully satisfactory, that sort of thing. So Chapter 14 of the guides requires assessors to follow a 3-stage process when evaluating mental and behavioral impairments. Stage 1 requires the assessor to determine whether or not there is in fact a mental disorder. So is there a diagnosis of depression or an adjustment disorder or post-traumatic stress disorder? So first they have to determine what the diagnosis, if any. Stage 2 requires the assessor to identify the impact of the mental disorder on the individual's daily life. So they do need to go through what this person's life was like before the collision and determine what impact, if any, the mental disorder is having on their ability to function. And then stage 3 requires an assessment of the degree or severity of the impact on the individual's daily life. And this is determined by placing the limitations into the four categories of functioning and assessing them based on the 5 levels. So first they have to determine if there is a mental disorder, and if there is such a disorder, what is the impact of that disorder on the person's daily life? And then 3, what is the impact of that mental disorder in terms of its severity from a class 1 to a class 5? If there is a marked or an extreme impairment, the insured person would then be deemed catastrophically impaired. Now, when the Pastore case, before the Pastore case came out, there was a lot of debate around whether or not one marked impairment would be sufficient for the purposes of catastrophic determination. And the debate really looked at, do you require 2 marked impairments, 3, how many are required? And Chapter 14 of the AMA guide sort of alluded to the debate, because what it said is this: in the ordinary individual, extreme impairment in only one class would be likely to preclude the performance of any complex task, such as one involving recreation or work. Marked limitation in 2 or more spheres would be likely to preclude performing complex tasks without special support or assistance. And so the guides seem to allude to there being a need to have 2 or more marked impairments to be catastrophic. And some clinicians interpreted this element of the guides to mean that there must be 2 or more marked impairments in order to be deemed catastrophic. And so what that means is, when you look at the 4 areas of functioning on the left-hand side of the screen, the assessors determined that at least 2 of them must be marked for there to be a catastrophic impairment. But in contrast to that analysis, the legislation did not read that way. So the statutory accident benefit schedule read as if only a class 4 or class 5 impairment was required, which implies that there was only a need for 1. So that's what Pastore dealt with. And it hinged on 2 major issues. The first issue that Pastore dealt with is, do you need a marked or extreme impairment in all 4 categories, or is a single marked or extreme impairment sufficient? And then the second issue that it looked at is, can physical pain be included in determining whether an insured has a marked or extreme impairment? Because what a lot of assessors tried to do was to separate out the physical from the psychological impairments and find a strictly psychological injury when doing the analysis from class 1 to class 5. And that's obviously very difficult, because an individual's depression, for example, is related to the physical pain and functional disability that they have because of that physical pain. So let's look first at the first issue, whether or not there need only be 1 marked impairment. And the Court of Appeal looked at the definition of the word "a," and according to its plain meaning, determined that it was singular, that it only meant 1. They held that interpreting "a" necessitates a singular marked impairment in only 1 of the 4 categories. So there is no requirement for an assessor to come up with an overall marked impairment amongst the 4 categories. The legislation was clear that you only need 1 marked impairment to meet the test. So moving to the second issue, can physical pain be included when determining whether there is a marked or extreme impairment? And the Court of Appeal found that there can be many causes of a disorder, both mental and physical. The disorder, which is the end result, may be mental, but that mental disorder could be brought about by both the physical and mental impairment. So again, if you're physically impaired and you're in daily pain, and because of that daily pain, you're depressed, how do you separate out the pain from the depression? And so because of that, what the Court of Appeals said is, you do not have to factor out the effect of pain. Any pain, whether it be physical or mental, which played a role in bringing about the mental or behavioral disorder, is to be included. This should be a cumulative approach. The legislation here is remedial, and it is to be given a very liberal interpretation. So, what the courts really made clear here is that the statutory direction that impairment be evaluated in accordance with the AMA guides should be given a very fair, large, and liberal interpretation so as to ensure that the objective of the Act is met, both in terms of its intent, its meaning, and its spirit. This is consumer protection legislation, and the definition of catastrophic is really just a door that opens for these individuals to potentially access benefits. It should be very much an inclusive definition. Now, before I move on, let me talk as well about multiple catastrophic applications. An insured person has a right to file a CAT application whenever that individual deems it appropriate. There is no time limit to file a catastrophic application. The insured person can apply and reapply at any time. So if the individual initially applies and is not deemed CAT, they can reapply 6 years down the road if their condition worsens, for example. So that's an important thing to remember. Now, I've gone through the pre-June 1, 2016 test, and I've gone through sort of the case law as it involved under that test. We then, from 1996, when the catastrophic definition first came about, all the way up to June 1, 2016, really lived during a period of what I would call catastrophic bliss. 20 years. Things seem to be going relatively well. At no time prior to these 2016 amendments did any of the stakeholders ask for there to be a reduction in the catastrophic limits that were available. Things seem to be moving relatively swimmingly. The vast majority of the claims fell under the MIG and the non-catastrophic category, and it was only a very small number. Some put that at 5 to 7% of the claims that fell within the catastrophic definition. And so everyone worked together well. It seemed to run swimmingly. Then along came the Liberals in June of 2016, and quite frankly, they completely changed the landscape for reasons that are really unknown to many of the stakeholders. At the time, they introduced a new catastrophic definition, which made it much more difficult to meet the test. And then to make matters worse, they also reduced the benefits that were available so that rather than having those $2 million in med rehab and attendant care benefits, individuals would only have $1 million. So let's recap what was in the old definition, and then I want to compare it to the changes that have come out post June 1 of 2016. So in order to be deemed catastrophic, and we're just really here going to talk about those main areas, those three biggies that I talked about. One was that GCS score of 9 or less. In the legislation as well was a Glasgow outcome scale reading of 2 or 3, which represented vegetative or severe disability. And that related to someone who maybe didn't have the GCS score, but was brain impaired and 6 months post collision was not functionally doing well. So both of those elements of the test relate to brain impairment. There was also the WPI, whole person impairment of 55%. And lastly, there was that single marked mental or behavioral impairment. So these were all changed when the amendments were made in June 1 of 2016, and let's look at how the government changed them. So what we're dealing with right now is what the current definition of catastrophic impairment is. And what's important for you to know is that the government put forth a different definition as it related to brain impairments for children versus adults. So let's first deal with the definition as it exists now or post June 1, 2016 for adults. So you'll recall that we had the GCS and the GOSI previously. The government has gotten rid of the GCS. So the GCS score is no longer pertinent to the definition of catastrophic impairment. All that matters now is that GOSI score, and which is the Glasgow Outcome Scale. And certainly the difficulty with this is that the GOSI is not regularly performed, whereas the GCS, as I mentioned, is performed by all ambulance attendants and emergency personnel. The GOSI is something that needs to be arranged and ends up resulting in additional costs throughout the course of the claim. The other change relates to the whole person impairment test. And what the government did there was to modify the test. They did not do away with it, but they did make some changes to it. And I will talk about those changes in a minute. And then thirdly is the marked impairment test. The government similarly modified that test and made it necessary so that there would need to be more than one marked impairment. And we will talk in a minute about what those modifications are. So let's start first with brain injuries in adults and the changes that were made to the GCS of 9 or less. So we now have a two-part test that is required to be met. So it's no longer as simple as it was before, where all we needed was that one score of 9 or less. We now need, first and foremost, positive findings on diagnostic imaging. So there needs to be a CT scan or an MRI scan that notes actual brain impairment, whether it be a brain bleed, or a hematoma, something on the imaging that notes a positive finding. Now, this can often be very problematic because, if you think of the individual who comes into the emergency room and has physical trauma as well as a brain trauma that maybe they can't see, it is often the physical trauma that tends to be attended to first. And so by the time they get around to doing the CT or the MRI on the individual's brain, there may not be positive imaging. Also, with brain impairments, people don't often notice that there is a brain impairment until after the person goes home and tries to get back into their regular life, and they notice memory problems and things along that line. So previously, though, under the old test, this brain imaging did not in any way play a role in the catastrophic determination. So once the positive imaging is determined, we then go to the second part of the test. And here's where we're looking at that Glasgow Outcome Scale, the extended version, so the GOSI. And there are three elements or three findings that could allow an individual to be deemed catastrophic. The first is if they are found to be in a vegetative state 1 month post-collision. The second, if they are deemed to suffer a upper or lower severe disability 6 months post-collision. And the third would be a lower moderate disability 1 year post-collision. So in order for an adult with a brain injury to be deemed catastrophic, they have to have both positive findings on their imaging and one of those 3 GOSI ratings. Without both of those things, they will not be deemed catastrophic. Now, the reasons for the government's move towards the GOSI and away from the GCS score relate to the fact that, as I mentioned, you can have a GCS score of 9 or less and fully recover and not have a need for this heightened type of benefits. Whereas the GOSI focuses more on the individual's functional outcome. So how they recover from their injuries, and are those injuries lifelong? The problem with the GOSI, though, is it delays the catastrophic designation. So someone in a vegetative state, for example, has to wait a whole month to be deemed catastrophic and have access to that higher level of benefits. Someone with an upper or lower severe disability has to wait 6 months. And if you'll recall, those who are catastrophically impaired have access to $6,000 a month in attendant care versus $3,000 if they are not catastrophic. And so the delay in accessing these benefits can be incredibly difficult for certain family members. I had a young lady who was very badly injured in a motorcycle accident. She couldn't remember her own name at times. She would get very upset while she was in the hospital, and the family had a choice between putting in place some attendant care for somebody to come in and watch and sit with her, or having the hospital restrain her. They felt that she was a danger to herself and others while she was in the hospital. But because she couldn't be deemed catastrophic at the front end of the file, the family couldn't rely on the full $6,000 in attendant care, and they had to find family members to sit with her, which resulted in a lot of caregiver burnout because it was primarily throughout the evenings and the night where she would get out of her bed and wander. And so it really is a bit of an unworkable situation in terms of delaying access to those benefits. So just to add my X to the GCS is certainly no more, and we are now dealing with the GOSI. So again, to recap, the GOSI has its emphasis on functional outcome, so how the individual recovers from the injury. The initial severity is not the focus of the GOSI, so you may have a very severe collision that takes place at the front end, but if the individual makes a good recovery, they will not be deemed catastrophic. This chart outlines what the GOSI is and how somebody falls within each category. So you can see at the top of the chart, vegetative state, which we know is one of the ways in which someone is deemed catastrophic. So basically everything highlighted in red would qualify for a catastrophic designation at the applicable time period. That highlighted in yellow may potentially be catastrophic if the individual's condition deteriorates, and that highlighted in green would not be deemed catastrophic. So for vegetative state, if someone is in a vegetative state at 1 month post-collision, they will qualify for catastrophic. And what this in essence means is that the individual is unable to communicate. There is, no ability for them to function, so they're basically in a coma, on a feeding tube, hooked up to machines, that type of situation. The second way someone can be deemed catastrophic is through the lower severe disability at 6 months post-collision. And this is someone who needs frequent help, or someone who needs to have someone around most of the time to watch him or her. So the main predictor of this element is the attendant care assessment. So if the individual continues to require 24/7 or significant attendant care throughout the day at the 6 month mark, that individual very likely will continue to qualify for or will qualify for a lower severe disability rating. The other category is the upper severe disability, which again at 6 months could qualify the person to be deemed catastrophic. This is someone who needs help, but maybe not as much as the person in the lower severe category. But the help is still frequent. The individual cannot be left alone for up to 8 hours a day. The individual needs cueing and reminders. The person cannot shop or travel without assistance. Again, the attendant care assessment here is really the best tool to determine this category as well. The third way or the fourth way in which someone can be deemed catastrophic is the moderate disability lower category. And the timing for this is that 1 year mark. So if at the 1 year mark the individual meets this test, the individual would then be deemed catastrophic. Now, the moderate disability is someone who still can't work at the 1 year mark and can't participate in social and leisure activities to the extent that the person did before the accident. There are constant, intolerable disruptions in the individual's relationships. So the attendant care also plays a role here, but it is not as important. But certainly if there is ongoing attendant care at the 1 year mark, that too would be a sign that the individual may qualify for this designation. If the individual has not returned to work, though, that is a big sign. So if the person is still receiving an income benefit or a long-term disability benefit, the person may meet the test here as well. The moderate disability upper is a situation where the individual is able to work, but that person is working at a reduced capacity or participates less in their social and leisure activities. Their relationships may have been disrupted at least once or more a week, but it is at the time to a tolerable degree. And then the good recovery, lower and upper, is precisely what it says. They've basically made a good recovery and would not qualify for catastrophic designation. The occupational therapist and the neuropsychologist are incredibly important when dealing with the GOSI. What you typically do is you have the occupational therapist do a full assessment and comparison of the individual's pre versus post collision life and activities. And then you have a medical doctor, such as the neuropsychologist, comment on the GOSI outcome and submit the OCF 19 application for catastrophic determination. Another thing that is sometimes helpful is to have the occupational therapist do a situational assessment where they bring the individual out into the community and see how they are actually functioning. So give them a list of groceries to go buy and bring them to the grocery store. And can they remember the list? Can they manage their way through the store and purchase the items and provide the correct change and get back home? And that situational assessment will often give more insight into the functional abilities of the individual.